When you need an attorney, experience matters.
Past success matters.
Attention to detail matters.
Prince Glover Hayes is celebrating 40 years.
40 years as a civil litigation firm.
And delivers over 100 years.
Over 100 years of combined experience.
We've been able to obtain some of the largest jury verdicts and settlements in the state of Alabama for our clients.
We will fight.
We will fight.
We will fight to make sure our clients
get the justice they deserve.
Here at Prince Glover Hayes, we counsel.
We advocate.
We litigate.
And we are devoted to helping you.
Hello everyone, along with Matt Glover, I'm Mike Royer, and we welcome you to People's Law School. People's Law School is brought to you by Prince Glover Hayes Law Firm here in Tuscaloosa. On this program, we deal with issues that are important to you and your family. And tonight's topic, 10 keys to getting top dollar in case negotiations. Your host for our program tonight, Matt Glover. Matt.
Hi, my name is Matt Glover, and I am a partner with the Prince Glover and Hayes Law Firm in Tuscaloosa. I've been practicing law at that firm since 2002. During that time period, I have been involved in cases that have either settled or been resolved by way of a jury in amounts in excess of $100 million. And during that time period, I have learned that one of the key techniques that any lawyer must learn is how to be an effective negotiator. And unfortunately, a lot of lawyers don't think about that because they've been told that the skills necessary to be a lawyer are: 1, you're good at arguing; 2, you're good at researching; 3, you're a good writer. But very seldom do you hear someone say that to be an effective and complete attorney, you need to be an effective negotiator. So the purpose of this discussion today is to talk about what does it take to be an effective negotiator, or specifically in relation to the type of work that we do, specifically representing injured folks from the state of Alabama. How do you get the top dollar? So I want to begin by talking about a conversation that I inevitably have with every client. And many times it comes in that first meeting when there's been an agreement to have our firm represent you. And the question that is often asked of me, or probably of any lawyer for that matter, is, what is my case worth? It's a great question, and it's completely understandable why someone would have that question. But here's the problem. And unfortunately, if you turn the TV on at almost any given point now, or you're driving down the road, or you're listening to the radio, you will hear one lawyer after another lawyer have a commercial about how this lawyer or that lawyer got this person or that person hundreds of thousands of dollars. Some will even have them hold up a check. But I tell people, look, those folks have no idea what your case is worth. And here's the reasons for that. Ultimately, in any case, if there is not a settlement, then a jury of people in Alabama make a decision about your case. They decide if you win, they decide if you lose, and they also decide, if you win, how much you are to receive. Well, if that case is in state court in Alabama, you have 12 people on the jury that will make that decision. Well, for a lawyer to really be able to tell you what your case is worth, they would have to fast forward 3 years. They would have to know who is going to be on the jury. They would have to know all of the evidence that came in, and they would have to know in advance the decision that the jury made in your case. There is no lawyer, no matter how good he or she thinks they are, who can tell you 3 years in advance what a group of 12 people whom they don't even know will ultimately decide to do in your case. So if a lawyer tells you your case is worth X, you really need to question whether or not that lawyer is telling you the truth. And so I often tell clients from the beginning, I can't answer that question today, but as time goes on, I will be able to give you a range of what I think your case is worth based upon my 17 years of experience and based upon the facts of your case. The second question that is often asked of me, not necessarily in that first meeting, but as we begin to have settlement talks, and it's a very important question, and it's one that I hear almost every time, and that is, Matt, how much are we going for? Again, it's completely understandable why a client would want to know from their lawyer, how much are we going for? But here's the problem with that. Let me give you an example. If I said to a client, well, we're going to go for $100,000, and you start the negotiations, and you get to a point where the defendant or the insurance company for the defendant is willing to pay $100,000. Well, if that's what we're going for, and that's what they're willing to pay, well, you have a deal, right? Great, you got a deal, you go home. But what if? What if that same defendant and that same insurance company was actually willing not to pay just $100,000, but what if they were to and willing to pay $175,000? Well, if I was going for 100 and we settled at 100 and walked away, effectively, I just cost you $75,000 because we left that on the table by not trying to get exactly what they were willing to pay. So I always tell clients, the question should not be, what are we willing to take or what are we going for? The question should really be, what are they willing to pay? Because if we can get the defendant or the defendant's insurance company to put on the table every penny that they have allotted for the case, then we can make a decision about whether the offer is in your best interest. So tonight, what I want to do is I want to share with you 10 techniques that will help you get that top dollar. It really begins with having the right mindset in a case. I don't mind to say this because I've seen it for 17 years. There are many lawyers who, when it comes to the topic of settlement, they make a decision that your case is going to settle. No matter whether it's a good settlement or a bad settlement. The business model is such that they take so many cases that in order for them to be a profitable business, they've got to get your case in the door and out the door in a certain period of time. And when it gets to the point where it's time for your case to go out the door, then whatever the offer is at that point in time, it's going to get settled. And that's not the right mindset to have. Matter of fact, at our firm, what we tell clients is we don't have the mindset that your case is going to settle. Settlement means you don't have a trial. Settlement means a jury didn't make a decision on your case. We've got to have the mindset that your case will not settle and that it will ultimately go to trial. And that if it goes to trial, that we're prepared to do everything we can to increase the likelihood that you have a successful resolution there. Well, why is it that it's important to have a mindset that your case is going to trial? Well, as we say, if we're prepared for trial, we're prepared to settle. But if we're just prepared to settle, that doesn't necessarily mean that we're prepared to go to trial. And so what happens if it's time for your case to go to trial and your lawyer hasn't prepared the case in such a way that it's ready for trial? Well, what does the lawyer have to do at that point? They've essentially got to accept whatever that last offer was because they're not prepared to go to trial. So what does that really look like? What does it really look like for a negotiator to prepare his or her case as if it's going to go to trial? Did you know that cases are expensive? For instance, if you come into our office and we agree to take your personal injury case, we're going to take that case on what's called a contingency fee basis, which means our payment is contingent. We only get paid if we get a recovery for you. If we don't get a recovery, we don't get paid. So to maximize the amount that you will be paid in order to get that top dollar, we've got to invest time and money into your case. If the case is not successful, we eat the expenses. But by doing the work that's necessary, we're preparing your case as if it's going to trial. Just a few examples. If there's a witness that exists, we're going to interview them. If there's a deposition or testimony that needs to be taken, we're going to take it. If we need to understand all of the applicable law in your case, we're going to spare no expense to do that. And trust me, as you prepare your case for trial, the ultimate value will go up. There is a direct correlation between the lawyers that prepare a case for trial and lawyers who don't. In essence, lawyers who prepare the case to settle. So that very first technique for any lawyer who's trying to maximize the value of the case for his or her injured client is to prepare that case as if it will be decided by a jury of 12 people in the state of Alabama. In addition to having the right mindset, you've also got to create the right impression. Let me explain what I mean by that. I currently have a trial that is scheduled to begin in just a few weeks. It's actually a case that was filed all the way back in 2013. So here we are, 5 years after the case filing, and the case is finally going to go to trial. Many times that's not a reflection of us, that's just a reflection of the number of cases that are in our court system. This particular case has 5 corporate defendants from out of state. And I'll talk about this concept in just a few minutes, but the closer you get to trial, the more serious people are about trying to resolve a case. Now, the impression that each of those 5 defendants have of your case is a reflection of what their lawyers think about the lawyer who is representing you. If the impression of the lawyer is one that he or she's lazy, he or she doesn't prepare, he or she doesn't understand, he or she is not willing to work late, he or she is not willing to go into the courtroom and risk a loss, that is an impression that will ultimately affect the value of your case. Impressions begin from day one. When the lawyers on the other side who are evaluating your case sees your lawyer working daily, weekly, monthly on your case, that sends a message. And the message that it sends is, we believe in this case. We take it serious. We're going to turn over every stone to find the answers to the questions of what happened, how did it happen, and what is that particular case worth. I must say, it's very disappointing when you go to court and you see a lawyer who doesn't know the details of their case. They don't understand the law. They're late. All of those impressions send the wrong message. And the message that is being sent is this client that I represent, their case is not important to me. And if it's not important to me, how will that ultimately affect the value of the case? So having the right mindset and making the right impression from day one are all part of increasing the value of your case. This is a good time for me to explain how most cases get resolved. There is a process that lawyers go through called mediation. Don't get caught up in the word. Mediation means formal settlement talks. Now, that's not to be confused with arbitration. Arbitration is a totally different concept where a jury doesn't make a decision, but it's actually an individual or two individuals who have a specialized knowledge in a particular field. No, I'm talking about mediation involving your case that will ultimately be decided by a jury. But think of it as formal settlement talks. And usually that comes up about a halfway to 2/3 of the way through your case. That's not a hard and fast rule, but from my experience, that's when it typically happens. Well, what mediation is it's a time when everybody involved in the case gets together. Often there'll be representatives from the defendants, the representatives from their insurance companies, obviously the lawyers representing them. Your client will be there, your lawyer will be there, and then there will be someone called a mediator who is really just trying to facilitate a deal. A lot of times we go to Birmingham to have our mediations because there are lawyers who do nothing but serve as mediators in the Birmingham area. Well, here is my experience that I have seen so many times. A lawyer gets in his or her car in Tuscaloosa. They've got their client. They're going to mediation. And they know before they ever pull out of the parking lot that at the end of the day, when the mediation's over, they're going to drive back and they're going to have a settlement. They view mediation as the end step in terms of just get there, see what they're willing to pay, and take it. An effective negotiator does not look at mediation as the end result, but rather a step in the process. If it settles for top dollar there, great. If not, you've used mediation as a tool to, again, communicate to those on the other side just how important you perceive the case to be for your client. Having the right mindset, creating the right impression. Now, if you try to settle your case too early, you will fall into what I call the trap of uncertainty. Now remember, the lawyers on the other side, they're trying to get the value of your case down. And so they'll say things like, well, you really don't know how the judge in your case is going to handle these legal issues. We really don't know how the witnesses are going to testify about what happened. We really don't know what the law will. We really don't know when the trial date will be. All of these we really don't knows are all designed to create uncertainty in your mind. And the more uncertain you are, the more apt you are to not be willing to take the risk and accept something less. So as an effective negotiator, you have to understand that uncertainty is going to be used against you. So in order to rebut that, in order to get the top dollar, you have to remove uncertainty. Uncertainty is something that is removed over time. We don't need to guess what the witnesses are going to say. We interview the witnesses. We don't have to worry about how the judge is going to handle any particular legal issue because we've researched the legal issue and the judge has made a ruling. We don't have to worry about when the trial is going to be because we have a trial set in 3 weeks. To be an effective negotiator, to increase the value of your case, you have to remove uncertainty. Have the right mindset, create the right impression, appreciate uncertainty, and where appropriate, obviously remove that uncertainty from the process. Mike, I understand we have a question.
Matt, this question comes from Catherine here in Tuscaloosa, and she asks, how do I know when to accept the offer? Should I always decline the first one? That's a good question.
Probably should decline the first one. What I always tell folks is it's a reminder. One, when it comes to settlement, believe it or not, you're the one that gets to make the decisions. I can't force you to take something you don't want to take. I can't keep you from taking something you do want to take. But look, you hired a lawyer, and I think you really need to trust your lawyer to guide you in terms of answering that question, when should I say yes and when should I say no? Perhaps one of the greatest things that a lawyer on my side can do to increase the value of your case is to appreciate fear as a motivating factor. Every lawyer that I have ever known is confident about their case and willing to go to trial, and they're going to win when the case is 2 weeks or 2 years away from the actual trial date. Check that lawyer's pulse the morning of trial and see if that lawyer has the same level of confidence. Many times a lawyer is not willing to go into the courtroom, and when they're not willing to go into the courtroom because of fear, the fear of what happens, well, that will lead to the value of the case changing. That's one item of fear that I'm speaking of, but the other item is this. Most of the defendants that we sue have insurance. And just as an example, if the defendant has $1 million in insurance, my job is to make that insurance company fear that a jury in Tuscaloosa County or Bibb County, Hale County, you name it, will in all likelihood return a verdict in excess, meaning more than that $1 million. If a lawyer can create that level of fear, then given the law in Alabama and the duties that insurance companies have, many times they have no choice but to say, we've got to pay the $1 million. And the reason is because they fear the scenario where a jury comes back and awards more than the insurance company had for that particular defendant. And when that happens, the defendant is on the hook personally for money. And if the insurance company did not settle the case in the protection of the defendant, now the defendant has a lawsuit against his or her insurance company for failing to settle. So lawyers who do this for a living know that the creation of fear in the insurance company's eyes that a likely jury verdict will be in excess of the policy limits for the defendant is the single greatest technique that a negotiator can use to get that top value. To do that, though, you have to do all those other techniques. You can't just say a jury is going to do this. You've got to be showing from day one of your case that you know what you're talking about. This is your area of specialty, and you're investing the time and resources into this case because it is important for your client. So how do you capitalize on that fear? Let me give you perhaps one of the best examples that I can tell you, and then here's how we do it. We don't try to guess what a jury's going to do. We conduct what we call focus groups. They're mock juries, where at some point in a case, we present both sides to multiple panels, multiple juries, to try to gain insight as to what a jury in Tuscaloosa or whatever county will do in your case. And when we're able to take those results and share those directly with the defendant and the defendant's insurance company, it's no longer Matt Glover just believing in his case. It is Matt Glover who has presented this case to a series of mock juries, and they have consistently awarded this particular type of jury verdict. That is capitalizing on the preparation of your case to create the fear in the insurance company. It is very important in a case to manage expectations because ultimately it's the client's decision and not yours about what to take. But if I haven't had a good relationship with my client, if I haven't told my client the good points of their case and the bad points of their case, if I have waited until the very end to try to talk to them about a reasonable settle amount, I have not managed the expectations of my client. And so if I'm in the negotiation and I'm on a separate page from my client, I can't get the top dollar because my client and we disagree about how a case should be handled. Too many lawyers wait to the end. The management of reasonable client expectations begins in that very first conversation when questions are asked like, how much is my case worth? And what are we going for? You need to tell your client the good, the bad, and the realities of the case that he or she has. You need to be proactive in your negotiation style. First off, you need to preserve negotiation integrity. I've seen too many lawyers that they'll say every time they started $1 million, every time they started $1 million, and every time they ultimately settled the case for 5, 6, 7 cents on the dollar. You don't have negotiation integrity when you do that. When you ultimately settle a case 5 cents on what you originally represented the case was worth. So have some integrity in the way that you negotiate. Obviously, always start high. You've got to leave yourself room to move. You need to be prepared to walk away. Again, there is nothing wrong with understanding that settlement talks, mediation, it's a step in the process. And if walking away sends the right message that we're not here to settle, then be prepared to do that. I've seen too many lawyers also just get mad. They scream. And many times they act like that because they're trying to mask or cover up other weaknesses that they have in the preparation of their case. Despite being at odds with someone's evaluation, always maintain respect and professionalism and realize that the lawyer that you may be belligerent to today is a lawyer that you're going to have to negotiate with tomorrow. Also, don't be predictable. Don't always settle the case in a range where the other side knows that you're the kind of lawyer that's always going to settle for $50,000 or $75,000. Finally, make sure you've got a lawyer who's willing to say that they have learned from his or her mistakes. At the end of every negotiation, I look over my notes and I try to see where could I have done something different. Because again, the goal is not to get what you're there to get, but to make sure that they are willing to pay all that they're willing to pay. So the next time you're looking for a lawyer, find one who can argue, find one who can write and research, but also make sure you've got one who's got a track record and a strategy behind getting the top dollar for his or her clients.
Matt Glover, thanks very much. Great information tonight on how to negotiate your case. Someone in the other room, as we watched you, said that Matt really knows his stuff. That's a good compliment for anyone and for you tonight. We hope you've enjoyed People's Law School. The program is brought to you by Prince Glover Hayes Law Firm here in Tuscaloosa. Thanks again for watching, and we'll see you again next time on People's Law School.
When you need an attorney, experience matters.
Past success matters.
Attention to detail matters.
Prince Glover Hayes is celebrating 40 years.
40 years as a civil litigation firm.
And delivers over 100 years.
Over 100 years of combined experience.
We've been able to obtain some of the largest jury verdicts and settlements in the state of Alabama for our clients.
We will fight.
We will fight.
We will fight to make sure our clients
Get the justice they deserve.
Here at Prince Glover Hayes, we counsel.
We advocate.
we litigate.
And we are devoted to helping you.
People's Law School is brought to you by Prince Glover Hayes as a community outreach class offered by the Osher Lifelong Learning Institute.